Well, good afternoon and welcome to today's presentation, Privacy Watch, our top 5 year-end considerations. My name is Josh Stevens. I'm a partner here at McMurray & Schuster. Before we get started, just a couple quick housekeeping notes. First, there will be no Q&A during this presentation because it is just a 30-minute condensed format. We don't do Q&A during it, but please feel free to put your questions in the question box and we will get back to you afterwards with answers. Also, the recording of today's presentation will be available at some point tomorrow on our website if you want to check it out or forward it to a colleague who wasn't able to attend in person. And with that, let's go ahead and get started, given we're on a schedule here. As I mentioned, my name is Josh Stevens. I'm a partner here at McMurray & Schuster, focusing primarily on privacy, data security, and marketing and advertising compliance. And in that role, I help businesses of all sizes, right, from startups to Fortune 100 companies and everything in between. And for today's presentation, what I really want to do is be able to give you some insights into what we're thinking about in our firm as we're coming up on the end of the year, and maybe some of the things that you might want to think about as well. As always, this is a high-level presentation. Do not act on anything that you hear today without talking to your own attorney and thinking about your own particular circumstance. What we're going to be talking about are generalities, not specifics, and especially in the world of privacy, small nuances can make a big difference. And so what are we going to talk about today? Our first two items both come from the CCPA and the California AG's notices of enforcement action that they published back in the late summer. And those are going to relate to the notice of financial incentive that's required under the CCPA, and also some insights around data collection tools. Then we're going to touch on the global privacy control, which the California AG recently endorsed. I'm going to talk about the CPRA's lookback period and what you might want to think about in relation to that as you're coming up on the end of the year. And then we're going to wrap up with a brief touch on industry barriers to tracking. And I probably don't have to touch on this for you all. If you're watching the presentation, you probably ran into some issues with some of the things that have been changing in the industry, but want to make sure that these things are on your radar. As I mentioned, the CCPA enforcement process has started. In fact, the California AG really began enforcement on July 1st of 2020. But this year they published a series of notices around enforcement actions that they had taken. And why this matters is if you think about the enforcement process for CCPA, the California AG, or soon to be the California Privacy Protection Agency, has a 30-day cure period written into CCPA. So they send you notice, you get 30 days to fix the problem before they start an actual enforcement proceeding against you. And there is a question about exactly what type of notice is needed to start that 30-day process. What we've seen so far are notices coming from the California AG's office. But back in the summer, they released a tool that allows consumers to generate a letter that can be sent to a business the consumer feels does not have a do not sell my personal information link on their website, but should have one. And the wording around this process was somewhat ambiguous and opened up a question of whether receipt of one of those letters directly from a consumer potentially starts that 30-day clock. So it's something to keep in mind if you receive complaints from consumers in California about failings related to the CCPA, that you may want to look into those and think about if any remediation is needed, even if that isn't an official notice coming from the California AG. Be interesting to see how this shakes out. But with regard to official notices that went out, where the California AG worked with a number of businesses in remediating CCPA issues, a couple jumped out to us and want to bring those to your attention. So the first one here relates to the notice of financial incentive. So remember, under the CCPA, when you offer a financial incentive to a consumer for their personal information, there's a notice that's required. Financial incentive is any type of program, benefit, or other offering that it could be payments to consumers, maybe discounts, things like service and price differentials count as well, that is connected to the collection, use, and disclosure of their personal information. And in this enforcement action, there was a grocery store chain that had a loyalty program. And in connection with that loyalty program, they collected personal information from the consumer. The consumer opted in to that program. And I imagine most of you probably belong to one or more of these frequent shopper or loyalty programs at some type of retailer. They're really popular. But this grocery store chain did not provide a notice of financial incentive to the consumer before having them opt into the program. And that notice is required. If you take a look at Regulation 999.307, it sets out exactly what's required in that notice. But at a high level, it explains the personal information that's collected, how it's used and disclosed. It talks about the consumer's ability to voluntarily opt in and also withdraw their consent at any time. It needs to discuss what they're receiving. So what is it that they're going to get out of this relationship? What is the incentive? The estimated value of the personal information that they are giving up in connection with this incentive, how that value is estimated. It's a pretty detailed notice. And I can tell you that from what I see out in the marketplace, it's something that a lot of businesses, I don't think, have given a lot of thought to. When I just went through several of the frequent shopper or loyalty programs that I belong to with numerous businesses, I noticed maybe only a quarter of them had this type of notice publicly available on their website. And so if your business offers a loyalty program or offers incentives to consumers in exchange for personal information, definitely have this on your radar and look at what you need to do to get your compliance up to snuff with regard to that. Another area outside of the loyalty context where I see this is with lead generation and potentially offering consumers incentives in exchange for them giving up information in connection with a lead. And so that's another area where you may want to take a look. The second category of enforcement actions that jumped out to us are related to automatic data collection tools. And when CCPA first came about, there was somewhat of an open question, although practitioners thought that the California AG might go a certain way on it, but there was a bit of an open question as to whether giving access to your website for a third-party analytics or advertising tool to collect information automatically from the users of the site and then use that information for their own purposes constituted a sale. And what we saw in the enforcement summaries are two examples where the California AG has resolved that question now, and they've resolved it in the affirmative. Yeah, it is probably a sale. The first is the one on the screen here with a social media company that exchanged information about the user's online activities with analytics providers. But you notice here it says, but did not post the required notices or provide consumers with methods to opt out of the sale of personal information. So we can infer from that that the California AG must have felt that the contracts with those analytics providers did not make them strictly service providers to the social media company, and that transfer was a type of sale. And we see another example, this relating to an electronics retailer that is even a little bit more explicit about how they maintained third-party online trackers on their website that shared data with advertisers, and they did not have in place the right opt-out methods as well. And so when I think about the impact of this, what it tells me we need to do, as advisors to businesses and when working in the business is first do an inventory. And you should be doing this anyway for purposes of drafting your privacy policy and maintaining your compliance program. An inventory of all of those third-party tools that are built into your site, whether they be for analytics or advertising, even maybe for functions. Just really cover all of them. Get an inventory, get a lay of the land. Then review the contracts that are in place with each of those providers and see if they meet the standards to be a service provider relationship under the CCPA. And if not, then I think you have to go through and either update those contracts to add in those provisions if it's appropriate, or if it's not appropriate, if this truly is a situation where they're not always acting as your service provider, then you have a decision to make, which is, do you pull out those tools? Do you create a technological solution to prevent those tools from running in, say, California, or for users from California? Or do you really truly update your privacy policy to indicate that that is a sale of personal information to those tool providers, which means you're going to have to understand what it is they're collecting in order to properly disclose that, and put in place a technical solution to honor opt-outs from sale of individuals who have exercised that right. And that's where the wrinkle really comes into play, which is, how do you develop a website? How do you structure a website so that you can prevent the collection by a third-party tool automatically of information that a user's device is giving up to a site, or that a user is plugging into a site and is being automatically harvested, but only for people who have exercised that opt-out right. I can tell you from working with clients, it's really tough, and there's no 100% perfect solution. There are third-party providers who can help, and who can, try to make it as smooth as possible, but it's really, really tough to do. And it especially is tough when you also think about the interplay with something that's mentioned here in this summary, which is the global privacy control. And so let's talk about that. You may recall years ago the do not track signal, and California regulations that required disclosures around whether the website honored do not track. Well, that concept is brought into CCPA through something called the global privacy control. But rather than do not track, it's meant to indicate do not sell. When the regulations came out, and we all were really focused on getting everybody up to speed for CCPA, there wasn't an endorsed standard. Well, over the summer, the California AG did endorse this technical standard called Global Privacy Control. You can find information about it at globalprivacycontrol.org, as the browser global privacy control for purposes of signaling that a consumer does not want their information sold. Essentially, how this works at a very high level is the consumer can set a preference in their browser or in a browser extension. And right now, for most consumers, it's probably by browser extension, because the main browsers that most people use haven't incorporated this fully yet, but you can get browser extensions to them to allow you to use it. And that broadcasts the signal out to the websites that the consumer visits, and then those websites have to be programmed in a way to be able to ingest that signal and behave accordingly. So let's say you have a website and you are receiving the GPC signal. What does it mean? Well, if you can tie it back to a particular consumer, so let's say, for example, that is coming from device ID specific number, and you also know that device ID specific number is related to consumer X, then you need to treat it as if it's a do not sale opt-out for that consumer holistically, as if the consumer went to your website's do not sell my personal information form and filled it out. If you can't tie that signal back to a consumer, then you need to treat it as if the information that you are ingesting in that session with the consumer is not for sale. And for a lot of our clients, that's challenging to do, because until a person reaches a certain point in the flow of the site, they may not tie that information back to a particular customer record in their CRM to be able to continue seeing that as a do not sell request. And they may take the data set from earlier in the flow and use it for certain purposes, but now they got to figure out a way to be able to flag certain records that those can't be sold. Again, this goes back to technical solutions. And no single solution is going to work for every website. It's going to depend on how your site is managed. But you need to keep this in mind, because one of the unfortunate things about its announcement is, while it was done just as a public statement that the California AG has endorsed this method, the regulations requiring its use were already in place. And it is a shall. If you sell personal information, then you shall be able to recognize these signals if you collect people's information online. And so definitely take a look at the website and talk to your technical teams if you work with California consumers and CCPA applies to you and you sell personal information. Continuing with the California trend, because that is the state that has the most going on kind of at the moment. Just a reminder, the CPRA, the California Privacy Rights Act, will be effective January 1, 2023. The regulations are not due until July 1, 2022, so you're really talking a 6-month window to deal with any regulatory changes. And there is an enforcement delay to July 1, 2023. But what I want to hit on for today's conversation is this sub-bullet on your screen, that the law applies to personal information collected on or after January 1, 2022. So if you think about this, you are talking about personal information that is collected up to a year before the law is actually even effective, and 6 months before we even have regulations to know what really everything we need to do is. And so what we've been advising our clients is to, if there's one thing that you can do by the end of the year to try to mitigate risk related to CPRA because of this look back period, is to go through your privacy policy and try to get it as close as possible to CPRA's requirements. That way, you're reducing the risk that a consumer may try to argue, or the California Privacy Protection Agency might try to argue, that you're processing of personal information that was collected after January 1, 2022, but before you really had everything in place by January 1, 2023, violates CPRA after that date. And so 4 areas where we recommend that everybody take a look. One has to do with sensitive personal information. And on the next slide, I'm going to go through what that means. But the key here is to identify sensitive personal information that you collect and to describe how it's used and disclosed so that consumers understand. And while that may already be somewhat covered under your existing privacy policy, what we think CPRA is really trying to do is to highlight that, right? And to use terminology that indicates to the consumer that this is sensitive PI and they need to pay attention to this. So taking a look at the privacy policy with that lens on that piece and getting that up and improving that element. Another area is to add information about record retention. CPRA has pretty detailed, depending on how you read them, requirements on disclosures for record retention. Most privacy policies these days go pretty high level on that element. And so you may need to bring more detail, more granularity around record retention into the policy. Also, adding information about profiling. We don't know, because most of the information and rules around profiling is going to come out in the regulations, we don't really have a great sense of how California is going to view profiling. But you can look to Europe, you can look to other jurisdictions and how they view profiling and automated decision making to get a sense of what it's likely to look like, and then maybe add some information to the privacy policy around it so that that piece is in place as well. And then all you need to do is tweak it a bit before January 1, 2023. And then lastly, verify that the purposes of processing are accurately disclosed, because under the CPRA, any purpose of processing that hasn't already been disclosed to the consumer, you got to get their opt-in to process their personal information for that purpose. So make sure that that list of purposes is complete and accurate. As I mentioned with sensitive personal information, there are several categories. They're here on your screen. I'm not going to go through all of them, but this is what California with CPRA is going to consider to be sensitive personal information. Remember, we also have Colorado and Virginia on the horizon. Virginia's privacy law comes into effect January 1, 2023 as well. Colorado's not until July 1 of that year. They both have their own definitions of sensitive personal data that vary a bit from this definition. And so when you're thinking about sensitive personal information, if Colorado and Virginia are going to apply to you, also look at it through that lens, so you can maybe have a more comprehensive definition, even if it means you're over-inclusive for a particular state. One thing I do want to touch on, though, is precise geolocation, because I've had some questions around this. Under CPRA, precise geolocation means within a circle with a radius of 1,850 feet. So it is pretty precise. It's not like zip code, it's not really even neighborhood, but you are really talking a fairly precise geolocation, and that's what they're considering for sensitive personal information. All right, and now moving on to the last topic that I wanted to hit on for today, and that is tracking and industry changes and the impact that they're having, because this is something a lot of our clients are really starting to feel pressure from. First, let's talk Apple. With their app tracking transparency change, they have really upended a lot of the social media advertising methods that a lot of our clients have used in their precision. Remember, ATT requires permission to track outside of an app. And this is using the IDFA, the ID for advertisers. Consumers, based on information we've seen, there aren't precise numbers, but just surveys that are out there, consumers do seem to be using that permission to say, no, I don't want to be tracked outside this app. And it's starting to have an effect. Earlier in the year, there was speculation that, well, Facebook, Snapchat, everybody would find a way to work around it. It wouldn't be an issue. But a Financial Times report from last week indicated that the social media giants, Snapchat, Meta, Twitter, YouTube, have taken a $9.85 billion hit as a result of app tracking transparency. One of the things it does not do is limit the tracking within an app. So if you take Facebook, for example, Facebook can still build a profile pretty easily off of the behaviors and activities that a consumer engages in while within the Facebook app, but it's when they go outside of the app that there may be other issues. However, in its most recent iOS and macOS updates, we've seen another suite of privacy tools coming out from Apple. These include mail privacy protection, which disables pixels in email. And that's something I know a lot of our clients use to track open rates, are the tracking pixels, and mail privacy protection disables those. There's the hide my email feature, which allows someone to sign up, make an account on a website using a unique email address, and any emails sent to that get routed to their main email address, but the business doesn't actually get their main email. And there's also private relay, which masks IP addresses. Consumers are really looking for privacy tools, and Apple has seen that and is meeting the demand. Unfortunately, for people who rely on heavily targeted advertising, with each of these steps, the precision in the targeting starts to fade. And it's going to be a similar issue with Google, right? So Google had announced that Chrome was going to phase out third-party cookies in 2022. That's since been delayed due to regulatory pressures and industry pressures until late 2023, but it's still coming. It's still expected to happen. Now they're trying to replace it with this thing called flocks, federated learning of cohorts, which essentially takes a large number of users who have similar demographic profiles, puts them together, and allows you to market to that group. The thought being that the individual essentially gets lost in the crowd if you're marketing to this group. And the way that this works is it uses some on-device in-browser processing to try to have anonymity. One of the criticisms of it has been that it essentially may be another way for Google to cement their hold on the advertising infrastructure of the internet. But if you use these tools, as you're moving forward towards the end of the year, going into 2023, you need to be thinking about how more and more consumers are going to start using these. They're going to start really valuing their privacy. And how do you adjust your marketing strategy and your tracking strategies to compensate? And it could be that marketing has to become less precise. It could be really focusing on opt-ins where you are getting people to affirmatively say, yes, I want to know more about your products, and you're hitting those batches of people more often. That's really more for the marketing folks. But from a privacy perspective, what this indicates is the continuing trend towards allowing consumers easier methods to hide their identity and to restrict the use of their personal information. And before we go, we did get a question before today's presentation regarding the status of federal legislation. There have been a number of federal privacy bills proposed over the past year. Not a lot of them have gotten a ton of traction, but one that I do think people should pay attention to is a funding mechanism in the Build Back Better bill of $500 million. It was $1 billion, it's gotten trimmed, but $500 million to bolster the FTC's enforcement in the privacy space. And potentially there's some legislation to allow the FTC to have an easier time being able to fine businesses for first-time privacy violations. And so in the absence of comprehensive privacy legislation at the federal level, it looks like the strategy could be to empower and embolden the FTC to engage in privacy enforcement using existing tools or slightly enhanced tools while federal privacy regulation is worked out, or the variations, the various privacy bills at the state continue to percolate through legislatures. It's going to be interesting to watch starting in next year, and if the Build Back Better bill gets passed, it'll be interesting to see what the FTC does. But I would say my confidence for comprehensive federal privacy legislation is not exceptionally high anytime soon, but encourage people to continue pushing for it, because that is something that is probably going to be needed in order to bring uniformity across the country. And with that, those are our thoughts for the end of 2021. I hope that you'll be able to take something from that to put it into your planning for the end of the year. And if you have any questions that you weren't able to submit today, contact information is on the screen. Please do not hesitate to reach out. Thank you for attending, and I hope you have a great rest of your day.